Political pundits say the race for the seat on the state Supreme Court is one of the most, if not the most important race in state campaigns this year. It would likely be the deciding vote in the case of the redistricting maps. Incumbent Republican Justice Paul Newby is facing opponent Democrat Appeals Court Judge Sam Ervin IV. Ervin is known to his friends as Jimmy Ervin, but he's listed as Sam Ervin on the ballot. That was the name of his grandfather, the North Carolina U.S. Senator who ran the Watergate investigation of President Richard Nixon. Ervin has been on the appeals court bench since 2009. Before that, he was a member of the Utilities Commission. We asked both candidates for an on-camera interview. Ervin's campaign declined, but Justice Newby agreed to talk to us. Justice Newby, what is your philosophy toward the role of being a justice of the state Supreme Court?
I believe in judicial self-restraint. There are three branches of government. Our framers had a brilliant idea as they shaped our government. It's the role of the legislative branch to make the law. The executive branch is required to execute, carry out the laws as anticipated by the legislative branch. And the judges simply apply the law as intended.
There is some concern that federal laws are overreaching and interfering with the state constitution. What do you think?
I think that that's something we as citizens need to be aware of. But quite frankly, that debate's been going on for 225 years. It's the 225th anniversary of the signing of the Constitution in 1787. And certainly North Carolina is the only state not to ratify the Constitution at its first constitutional convention. And we did it for two reasons. One was that the language itself begins, we the people, not we the states. And we, as the sovereign state of North Carolina in 1788, was very concerned about that. Also, there was no protection of fundamental rights and freedoms. The Bill of Rights was proposed and ultimately ratified to address that. But this whole idea of the role of states, very important. And when you have a U.S. Supreme Court that now has ruled under the power to tax, that you can tax not doing something, we need to be concerned. We need to once again rally the cry of the anti-federalist and say, you know, the 10th Amendment has got to have some meaning. The 10th Amendment says every power not granted to the federal government is reserved to the states. Well, what power is that? If you can tax not doing something, what's left? So yes, it's an area of great concern.
Are you in favor of keeping the judicial campaigns nonpartisan?
That's a difficult question. Let me tell you why it's difficult. I'm fortunate to be endorsed by 4 former Chief Justices, 2 Democrats, 2 Republicans. They can do that because they've read my opinions and they say, Justice Newby simply follows the law. Lawyers, regardless of political philosophy, appreciate the judicial philosophy that the law needs to be consistent and it needs to be predictable. At first, it kind of bothered me that I'm a predictable justice. But the more I've thought about that, that's a compliment. That's what I want. When I practiced law, I wanted the judge to be predictable. I could handle whatever as long as I knew what direction the judge, what the judge required. So to be consistent, to be predictable. So on the one hand, I benefit from it being a nonpartisan race. I've had district attorneys and sheriffs, lawyers, people that I've practiced with all across the state who have endorsed me. Even though they are registered Democrats, I'm a registered Republican, I have benefited from the bipartisan support, and I'm grateful for that. On the other hand, from a public policy standpoint, putting my race aside, from a public policy standpoint, is it better for judges to be elected with less information or more information? And as much as we may want to idealistically believe that the voters will go to the websites of the different judges, maybe even go pull up a case that we've written and read it, that's not realistic. And I'd rather lose because I'm a registered Republican than because my name is Newby and nobody has heard any newbies, or the vernacular is a newbie. That's somebody who's trying something for the first time. We don't want any newbies.
So the bottom line, why should voters pick you?
For the last 8 years, I've had the privilege of serving on the state Supreme Court. I've written more opinions than anybody else. I have great bipartisan support from former judges, and particularly, as I indicated, the former Chief Justice, 2 of each party. They read my opinions. They say, Newby simply follows the law. If people believe that judges should not legislate from the bench, if they believe that judges should simply fairly and impartially apply the law to each case in a predictable, consistent manner, then I believe I've earned their vote.
On his campaign website, Irvin says law is the glue that holds society together. He says he applied it dispassionately, fairly, and conscientiously. Among the endorsements listed for Irvin are the AFL-CIO and the North Carolina Association of Educators. Newby received the endorsements of several former appellate judges, including 4 former Chief Justices. I'm Matt Willoughby.